Due Process, winner of 21 regional Emmy Awards, including the 2010 New York Emmy for our coverage of voting rights and the 2012 Mid-Atlantic Emmys for Outstanding Interview Special and Outstanding Discussion Series. Due Process is a presentation of Rutgers School of Law, Newark, and the Edward J. Blaustein School of Planning and Public Policy. Studio facilities provided by the Rutgers ITV Studio, Division of Continuing Studies.
What does it mean to be presumed innocent if you've already done 3 years of a jail sentence before you've even gone before a jury?
It's what can happen if, like 40% of our jail population, you can't make bail. Most locked up for nonviolent crimes, most black and brown and poor. They're there because they can't pay to get out. So is justice based not on what you did, but what you've got? Bail, on this edition of Due Process.
Major funding for Due Process provided by the Fund for New Jersey, supporting informed citizens for an effective democracy.
You're arrested, charged with a crime, brought to court. So what happens next? Well, that probably depends on how much is in your pocket or your bank account. If you can't make bail, no matter how small, you'll be placed in a cell pending trial, and you might be there for years. I'm Raymond Brown.
And I'm Sandra King, and on this edition of Due Process, an unflinching look at the New Jersey way of bail. It's a far cry from what you see on Law and Order, raising questions about class and race and what's done every day in the name of justice.
Mr. Rivera, please step forward.
You did plead guilty.
Yes.
Weren't you guilty?
No, I wasn't guilty.
So why would somebody plead guilty who wasn't guilty?
Like I said, I just wanted to get out.
But you want to continue with the sentencing today because this is a negotiated plea agreement. You understand that?
That was your only way out?
Yeah.
The only way out after almost a year locked up.
Your Honor, Mr. Rivera was incarcerated from May 25th, 2012 until April 9th, 2013.
And in jails across New Jersey and the nation, that stretch before conviction or even indictment is not unusual.
There's a huge problem with the bail system, that there are thousands, millions of people nationally who are being held because they can't afford often small amounts of bail.
For Victor Rivera, freedom could have been bought with
$25,000 bond or $2,500 cash.
He couldn't come up with $2,500 cash.
That's what kept him incarcerated for 11 months, $2,500.
If he had been somebody with access to just a couple of $1,000s,
It would be a different story.
So the purpose in New Jersey is to ensure your presence at trial. But what we've in fact done is replaced it with a system that so heavily relies on money bail that it keeps poor people in jail pre-trial, and the functional effect is that it extracts guilty pleas from innocent people on a routine basis.
if you had waited to go to trial, how long do you think you would have been in there?
15, 16 months.
Good luck, Mr. Rivera. Someone from probation will be up.
Charged with verbally threatening a cop, Rivera's guilty plea led to time served and release.
When they come up to court and they have that much time in and they're made an offer where they can go home, it's a hard offer to refuse.
If we hadn't took the plea, we could have sat there for 5 years. We could have sat there for 5 years.
Without a trial.
Without a trial.
Ricky Robinson and two co-defendants, insisting they were innocent of breaking into an abandoned dairy, but unable to make bail, held out for 21 months in the Union County Jail, their trial repeatedly delayed before they finally gave up and said guilty. So Ricky could have, with $5,000 and a bondsman, gotten out.
Yes.
$5,000 was not something he could make.
He could not. He was indigent. he is a very poor person.
How typical is that of your clients?
That's very typical. Most of my clients are very, very poor.
Most Black or Latino, most unable to make even small amounts of bail.
40% of the people who are in our jails are there strictly because they cannot afford the often nominal amounts of bail that they've been given.
And 40% is no guess. It's based on a study of New Jersey's jails commissioned by the Drug Policy Alliance, showing who's in, for how long, and why they're there.
The average length of stay is 10 months, all because that person couldn't afford a few $100s in bail.
You say that's discrimination.
It's discrimination because whether or not you are released in New Jersey is based on resources and not on your risk to the community.
And even the governor thinks risk, not resources, should be the standard.
So I ask you to approve my bail reform package, which would mirror the federal system. It would keep offenders with a history of violence who are a danger to our communities in jail until the time of trial, instead of releasing them back into society to prey on the public.
The Chief Justice has weighed in too, naming a committee to study the problem of backlogged cases and less than speedy justice, citing the Drug Policy Alliance survey.
We need to consider the study in light of the issue of speedy trial and pretrial delay, because what it means is that some inmates who are unable to make even modest bails are held in custody pretrial potentially for extended periods of time. And that's not a healthy practice for a system of justice.
So bail reform advocates say that's more official support for change than they've ever had before, but they would go much further.
Some states have done the right thing and they've moved away from money bail, and they've looked at other conditions that might ensure a defendant's presence. So maybe it's requiring drug treatment. Maybe you have to report once a week to a probation officer. Maybe you have to wear an ankle bracelet and have real, serious, speedy trial protections that ensure that, except in the most extreme circumstances, you don't have defendants who are incarcerated pre-trial for years.
So these 11 months that Victor Rivera served in the Essex County Jail had nothing to do with whether he was a risk to society?
None at all.
Nothing to do whether he was a danger to the community?
Nothing to do with ensuring his appearance at court either, which is really what bail is for.
So what was it about?
It was about not having enough money.
Not being able to come up with $2,500.
Exactly.
So was Victor Rivera actually guilty? I have no idea. But whether he was or not, his inability to make bail and his guilty plea were inextricably connected. Is that something that should concern, even upset, our faith in a fair and just system?
For what I expect will be some very different answers, we turn to two men from two different sides of that system. John Molinelli is Bergen County prosecutor and former president of the State Prosecutors Association. Joe Krakora has been doing public defender work for 27 years, for the last 2 as New Jersey's chief PD. Welcome to both of you.
Glad to be here.
John, let me start with you. We've seen the Chief Justice set up a committee which is going to have a number of criminal justice stakeholders on it. He cited in part the Drug Policy Alliance report as a reason for it. Are you convinced that there is a serious problem in bail in New Jersey and that we need to make some structural changes to address it?
I don't know whether I can answer that from a
Well,
systemic
it was a loaded
standpoint.
question.
You know, systemically, I don't know whether I have an answer for that. As a prosecutor, I don't want to see someone plead guilty just because that's going to get them out of jail. I think there are other ways around it. I mean, you know, what is the likelihood that he is going to flee? That really is the standard. So someone that has already been in jail, a time equal to what they would get if they were convicted, to me, would be a very strong basis for a defense attorney to make an application to have his bail changed from $2,500 to a recognizance bail, because he's not likely going to run if he...
Before we break it down into the practical aspects, as you will, is there something about having people in jail for what are nominal amounts of money, when the logic of that amount of money keeping them coming back to court seems a weak read?
Of course. Yeah, no, I can't disagree with that. I mean, for $2,500, based upon the number of people, I read the report. I was at the State Bar address by Chief Justice Rabner, and as a prosecutor, there is always a need to reform, particularly when you have individuals that might be innocent and extending their time in jail waiting to be heard. But it deals with so many issues, Ray, that I'm not sure that there's one answer. Yes, there could be more criminal judges, and there could be more resources available to get them the speedy trial that they deserve. But we all know at this table that just adding more judges into the process is not likely going to happen in today's economy. So I can't sit here as a prosecutor, but I do know that it's based upon, and should always be based upon, is the likelihood that they will appear. And someone, I don't want to get back in because I know you want to get back into it, but it should be a factor that if a judge is set $2,500 bail, it's not a large amount. So in all probability, the person is going to appear, is likely to appear.
So, Joe, even our friend the prosecutor says there's something wrong with this system. It would appear to be so clearly flawed, and yet here we are, stuck with a system that we have had forever. And how do we get rid of it? How did we get here?
Well, I think historically the notion has been, underlying all of this, is that if a person has money on the line, he or she is going to be more likely to go back to court. But I think the reality is that that's a fiction. I can't tell you how many times over the years we'd have clients in the public defender's office unable to make $500 bail, $1,000 bail, $2,000 bail.
And
judges,
how long might they then wind up in detention?
Well, in this state, in almost every county, you sit in jail for at least 4 to 6 to 7, sometimes longer months just before you get indicted, much less before you get a trial. Some of the statistics in the Drug Alliance study were alarming in terms of the length of time that people sit in jail in this state to get a trial.
Report shows I think the average is 10 months, and that includes people who are in for years.
Well, 10 months, that's not to get a trial. Maybe that's to when your case gets disposed of. But we have clients right now all over the state sitting in jail, 14, 16, 18, 20 months without a trial.
The longest you've ever seen?
Well, probably 3, 4 years without a trial. But it's the norm in most counties that you sit in jail for at least a year and up to 2 years before you get a trial. That is standard. And the worst thing about it is that basically people are serving their time before they've been convicted. You get arrested, you're charged. You haven't pleaded guilty, you haven't been found guilty by a jury, so you sit in jail so long that you've done the time before you've even been convicted. And the examples in the opening that's routine in court in the state. That is routine.
John, let me now do what I think you want to do, start to break the problem down. The first point is, of course, that a person in jail who hasn't been tried is by definition not guilty. So you do have the specter of a not guilty person in jail, maybe under circumstances where the only thing keeping them is that they're poor. Secondly, you have the problem of people feeling pressure to plead guilty after a certain amount of time in jail. And that's offensive if they're not guilty, but maybe it's even offensive if they're guilty, because even a person who might be culpable, who really maybe did it, is entitled to make the decision to plead or not, free of coercion from being in jail. So are there different solutions to different part of that problem? Is that what you were trying to say?
I think there are. I'm very reluctant to latch on to a principle that bail should be tied with one's ability to pay, though. I mean, I'm concerned about that. I recognize that it's a problem. I recognize you've got rather small bail amounts. But when we begin to look at things...
Before we go further, does that mean you're open to the possibility of having a system where there's less and less reliance on money as a guarantor of returning?
I would not be opposed to alternatives to bail that are based upon bracelets, that are based upon other means to ensure that the accused reports to court, because that really is what we're talking about. What I don't agree with, and I have to disagree with Joe, when you have a case where somebody has been in jail for a time that even upon conviction, they would probably be in a time-served situation. If a defense attorney brings an application to change that bail from $2,500 to ROR, where they're released...
By ROR, you mean your own recognizance?
On their own recognizance, okay. Right. I don't know whether our office would oppose that, because the person now is not likely going to flee and not attend a trial that even upon conviction, they probably will not serve another day.
And you can stop in this, Joe. Are you finding that true around the state, that as you approach the limits of what a person would probably get if they got convicted?
Well, it's dependent on a judge deciding to release that person, and that's what doesn't happen. And consciously or unconsciously, judges driven by the need to resolve cases have an incentive to have people in jail who are going to plead guilty because they've done the time.
I want to come back to Joe, but Joe, what you just said is pretty profound. That in a state where there's no history really of corrupt judges, there are judges who nonetheless are willing to let time alone clear the calendar?
Well, otherwise they would release people who shouldn't be in jail by either lowering their bail to something they can make or by releasing them on their own recognizance with some conditions attached.
John,
and they don't do that.
The coercion question is a huge one. And I think, with apologies for asking you the toughest question, how do you square the fact that you know that people who would not plead guilty if they were out are willing to plead guilty, walk out with time served, and say, okay, I'm at least out of here? Because your people are part of that negotiated plea, knowing that, in fact, the guilty plea may not be exactly kosher.
Okay, the last part you just added changes my answer. Before you added that, and that one that you just added makes it the million-dollar question. That's what makes it the hard question. I don't doubt that it happens, but I would say that if an individual is going to come into a court and plead guilty, and 2 minutes ago through counsel they just told us that they're really not guilty, but they're pleading guilty, I would hope that no one in my office takes that plea.
Yeah, but the lawyer isn't going to say, my client's not guilty, but he's willing to plead. He's going to say, okay, we'll plead in exchange for.
I hear you. Well, and the reason why we don't want that is because 3 months down the road you're going to get a post-conviction.
But isn't it what you have? And how do you square that with your own sense of justice?
It's easy. You don't take that plea. You don't, because for a lot of reasons. One, we have an oath. We don't take a plea that we know the person is really claiming to be not guilty. Two, it's going to come back. It's going to come back on a PCR, a post-conviction relief motion. They're going to say, I want a trial.
No, chances are it won't come back. Statistically, it's not going to come back, is it, Joe?
She's trying to put the hard case to you, which is, we all sitting at this table know that there have been people who, under the pressure of time, have pled guilty to crimes for which they weren't guilty. You might not have been able to easily deter it or detect it, which is maybe more the point. The question is, this is a system that will produce those kinds of results, and even though we can't cite jot and tittle, we know that it happens.
It does. I'm not going to deny the fact that it does. It's a consequence of what Joe was just suggesting. Is there is a need to dispose of cases, and there are times when we know that a particular plea offer is made based upon the fact that a person has already served a period of time. I'm not going to deny that that does not happen. It is not a conscious effort by a prosecutor to take advantage of the situation.
No, but are you then prepared to join Joe on the barricades and say, we need to fight this, this is not justice?
Well, it depends on where Joe is on the barricade. There are areas where I do not think that judges should begin to consider one's ability to pay in setting bail. On the other hand, as a prosecutor, I would not oppose alternatives to incarceration pre-trial where we, or I should say I as a prosecutor, believe that this person is not a considerable flight risk. And again, and I have to join the governor here, when you deal with violent offenses, the stakes become substantially different. Although more likely an individual that's in jail for a violent offense is a higher flight risk. So it all comes back to that issue. What is the person likely going to do when they're released?
But Joe, we just had a case here in New Jersey of a guy who supposedly, allegedly, hired somebody, wanted to hire somebody to kill his business partner, torture him on the way, and maybe kill his wife. That guy got out on $600,000 bail by posting a surety bond.
Right. Well,
so even in the most heinous accusation, we do offer bail. That's how the system works in New Jersey.
Right, and my point is, my thinking on this has changed dramatically over time, because my feeling is we need to have a more intellectually honest process by which we decide who should be released pretrial and who shouldn't. If you were to say to me that this gentleman, and let's assume to add to the facts that he had some prior criminal record on top of the charges in this case, if you were to say to me that the system is going to make a decision that this person should be detained pretrial because he's a violent threat to the community, I could live with that. If you're not going to have my clients from the public defender's office sitting in jail on $500, $1,000, $1,500 bails, I can live with that.
So you go halfway with the governor.
So you could you could live with the governor's proposal, which seems to include the notion of maybe no bail in violent cases, if it was tied to a notion of non-monetary consideration.
I actually have come to believe that some form of what was known as preventive detention, in other words, a judge ordering someone detained pretrial with no bail based on a finding of dangerousness to the community, I've come to the conclusion that that is almost essential to a system that at the other end presumes the release for the rest of the defendants. In the District of Columbia, I sat in court recently. I sat an hour in arraignment court. Money was not mentioned once. Defendants charged with murder were given hearings within 10 days to decide whether they should be released or detained without bail. It was remarkable. 85% of the defendants are released pre-trial.
But doesn't that effectively shift a lot of the responsibility for the bail decision even more to the prosecutor? Because by charging certain offenses where they have discretion, they can enhance the possibility that somebody will be detained.
Well, there's some truth to that, but on the other hand, the defendants are entitled to probable cause hearings and detention hearings within 3 days for many types of violent felonies, and within 10 if charged with murder or attempted murder. And the law presumes release in all criminal cases.
So, John, if there were a system where there was a combination of what Joe and the chief seem to be talking about and what the governor is talking about, would you be an advocate of having some quick hearing after no bail has been set, so that the defense can challenge the underlying assumption?
Well, how does that differ now? You know, when an application is made by defense counsel for a bail hearing, they're usually heard very quickly. I mean, I don't know how that would differ.
Except that you might have a greater opportunity to get to the merits if the hearing were set to address the issue of whether this really is a case that should be
The merits of a case are always brought out in a bail hearing. The judge wants to hear what is the strength of the state's case. That is a factor in the amount set by the court in bail. If you don't make that a factor, and that's what I think what we're suggesting here is the merits of the state's case will no longer be a factor. We're just going to look at the offense on its face, and we're going to have a certain set of offenses where there's going to be a presumption that they should be released pretrial, the nonviolent offenses, and other offenses where they should not be released pretrial. I'm very reluctant to just simply say that's the answer, because there's no review, there's no independent process where you're still getting back to what is the likelihood that this person is going to appear in court, which is why I would advocate alternatives to incarceration pretrial.
With 2 minutes left, let me just ask you, where do you think we're likely to go with this in the short term? It's not so easy as just even getting the law changed, right? We've got a constitution to deal with here.
Correct, and the Constitution in this state requires that all defendants get bail except if you're charged with a capital offense, which
so how do we change that?
We'd have to amend the Constitution, and we'd have to eliminate this provision that guarantees everyone a right to bail.
You're both politically astute. How likely is that to happen?
Well, see, I think this can work, because you have, at one end of the spectrum, you have maybe the prosecutors of the world who think, and maybe properly so, that certain defendants should be locked up on a finding of dangerousness. And then you have the public defender's office over here with hundreds or if not thousands of clients on jail on very low bails. One other point that I think is important in response to what John says is that under the scheme in D.C., for example, there are two things the judge is considering. The judge is deciding whether there is any conditions of release that will ensure the defendant's appearance and protect the community. It's a two-prong application. It goes to both risk of flight and dangerousness. And the government has to establish that there's no set of conditions of release that will ensure that the person come in and protect the community. That's a high burden, and that's why 85% of the people are released.
I hate to ask you almost yes or no question, but given the fact that you have the governor and the chief justice both focused on this issue, what are the chances of significant change in the system in the next year?
If the judiciary felt that somebody being held in jail at $1,000 was no different than releasing that person and to wear a bracelet, as a prosecutor, I can't speak for 20 of them, but I can speak for one, I would have no difficulty.
And a yes and no from you, Joe?
I'm very optimistic, and I think the Chief Justice's comments reflect a real desire on his part to give meaningful
And we are going
review.
to have to leave it there, with our thanks to Joe Krakora and John Molinelli. But it's a conversation we hope will continue. In fact, we'll have more on the complex question of guilty pleas next week, when Rutgers law professor George Thomas talks about his new book and how plea deals, inducements, coercion and bail have made the criminal confession the overwhelming norm. It wasn't always so, Raymond.
Till next week, check us out on Facebook and Twitter. Visit our website at dueprocesstv.rutgers.edu. You'll find every episode of Due Process on demand, and you can leave your comments and ideas on our contact page. We'd like to know what you think. For Sandy and all of us here at Due Process, I'm Raymond Brown. Thanks for watching.
Here's how it works. You've got two different people. They're both charged with the same thing. Let's say it's burglary, and let's say neither of them have a criminal record. Under our laws, they're entitled to what's called the presumption of non-incarceration. And let's say it's a bad case. The state's proofs are very weak. For the defendant who makes bail, who's at liberty while he litigates the case, they're going to offer him probation, and he's going to say, absolutely not, I want to fight this case, I'm going to put the state to its proofs. But the defendant who's held in jail, who after 6 weeks, 8 weeks, 4 months, 8 months, comes to court and is told, listen, you say you're innocent, we understand that, but if you plead guilty now, you will get out of jail today. He's taking that case 9 times out of 10, if not 99 times out of 100. And it has nothing to do with guilt, it has to do with the practical reality of how crummy it is to be in jail.
Coercion.
Effectively.
Want even more insight on law and justice? Become a fan of Due Process on Facebook. Follow us on Twitter and watch us on demand on YouTube.